Supreme Court upholds the injunction against Utah's trigger law. Senator Dan McCay is the author of that law. Now you want a special session. For what?
Well, we passed a trigger ban in 2020, and the thought was if we take our current law has a gestational ban after 18 weeks. And so all we do in the special session is move that from 18 weeks to 6 weeks, which the Supreme Court in the United States has already said is constitutional.
So the ban on abortion for most abortions in Utah would be 6 weeks.
Yes.
And that would replace or be in addition to the law that's already on the books.
That'd be in addition to. So while we wait for the courts to adjudicate the other matter, we move the gestational ban to 6 weeks.
How disappointed are you in the Supreme Court decision?
Well, litigation is a marathon, right? And unfortunately, we had a rough first mile, but there's still 25 to go. We'll be fine.
The pro-life leaders who you spoke with this morning said the aim here is to save babies. Mm-hmm. How many abortions have there been in Utah since the injunction went into place?
Since the injunction went into place, we're around 2,500 a year, so we're around 6,000 abortions have occurred since the Dobbs decision was overturned.
All right. So the majority opinion, though, today was, look, Planned Parenthood does have standing.
Correct.
That it could be harmed because of this law. What about that?
Well, standing is a very complicated argument that happens in this appellate level for years, and will continue to be complicated. I believe that if you read the dissent, that Justice Durant was right and took the right approach to this, and that Planned Parenthood doesn't survive as a plaintiff. They need an actual Utahn. The law actually requires in standing that it's impossible for no one else to qualify for standing in order for third party or even public interest standing. Well, in this situation, there are millions of people who qualify as a potential plaintiff, and as a result, Planned Parenthood shouldn't have standing.
There are people, of course, who disagree with you strongly and say, strange to break this news to breaking news now, but they do, and they say, look, this ought to be a woman's right. They call it a right, even though the U.S. Supreme Court has ruled the way that it has. They also say that a woman should have the choice, and to those people who have that very basic argument against your position, you say what?
Well, I say the rights that we are guaranteed by our Creator are enumerated in the Constitution, and we've captured them in the Constitution. And if you can't find it in the Constitution, it's not a right, and you're misnaming it. And I would say in a lot of ways you're doing a great disservice to everyone by calling it a right when a right doesn't exist.